Have you ever heard of goldbacks? Or the Liberty Dollar? Maybe you want to check that out. That's pretty neat. Anyway, today's lesson, I'm just simply going to repurpose old videos that I have made. We'll talk about case law. We'll talk about the CFR, or Code of Federal Regulations. We'll talk about the United States Code, which are legislations, acts of Congress that have been codified. A lot of information up front so that we can give it its place in the curriculum as I develop it more fully with the time I have available. Okay, so thank you for your patience. As this probably seems very discombobulated, it'll all come together, and I'll make it sequential and digestible, spoon-fed. Right? Thank you. Enjoy. So if you don't know, you can go to casetext.com and look up certain relevant court cases. This is Thompson versus Smith. Here's the details, right? 1930, Supreme Court of Virginia. We're going to start with the opinion part. The right of a citizen to travel upon the public highways and to transport his property thereon in the ordinary course of life and business is a common right which he has under his right to enjoy life and liberty, to acquire and possess property, and to pursue happiness and safety. It includes the right in doing so to use the ordinary and usual conveyances of the day, like a modern automobile, for example. We're going to go to the CJS, 60 CJS motor vehicles. CJS means Corpus Juris Secundum, which is the second body of law. It's an encyclopedia of United States law at the federal and states level. Section 210 talks about persons or vehicles excluded or exempted, okay? Statutes applicable only to motor carriers operating on a commercial basis for the transportation of goods or passengers do not apply to persons transporting their own property or employees, and although a private carrier may be required to obtain a special license or permit, such a carrier is not subject to provisions applicable only to common carriers. Please check out the green here. Statutes that require a special license, permit, or certificate of public convenience and necessity for motor vehicles do not apply to vehicles used only for the owner's personal or private pleasure or convenience. So you do not need a driver's license to travel freely on the roadway. And here we are, 49 CFR 390.5, definition just like you said. Nothing really to take note of, unless specifically defined elsewhere in this subject. Motor vehicle means any vehicle, machine, tractor, trailer, or semi-trailer propelled or drawn by mechanical power and used upon the highways in the transportation of passengers or property. Okay? Or any combination thereof determined by the Federal Motor Carrier Safety Administration, but does not include any vehicle, locomotive, or car operated exclusively on rail or rails, or trolley, bus operated by electric power derived from a fixed overhead wire furnishing local passenger transportation similar to street railway service. Driver means any person who operates any commercial motor vehicle. So let's look at person. Person means any individual, partnership, association, corporation, business, trust, or any other organized group of individuals. Operator just simply means driver, which we already saw. You might as well pause to read, but commercial motor vehicle means any self-propelled or towed motor vehicle used on a highway in interstate commerce to transport passengers or property when in the vehicle. It has those sub-listings. So unless you're a corporation who is operating any conveyance for commerce, you're not a driver. This is 49 CFR subpart A. We were in 390.5 for the definitions, right? But let's look up the general applicability of those definitions in point 3. You can feel free to go here yourself and read these. The rules in subchapter B of this chapter are applicable to all employers, employees, and commercial motor vehicles that transport property or passengers in interstate commerce. But dude, that's just subchapter B, which would be general requirements and information. Yeah, that kind of covers it all. But anyhow, let's go to the exceptions. Let's put the final nail in this coffin once and for all about driving and travel. Here we go. Exceptions. Unless otherwise specifically provided, the rules in this subchapter do not apply to number 3, the occasional transportation of personal property by individuals not for compensation and not in the furtherance of a commercial enterprise. Thank you. I think we can put this issue to rest. If you're traveling, you're not driving in commerce, and you're free to exercise that right of locomotion. There you go. Not gonna lie, totally thought you had me on that. So we're 49 USC 3102, right? Section A. Number 7, right? Motor vehicle means a vehicle driven or drawn by mechanical power and manufactured primarily for the use on public streets, roads, and highways, but does not include a vehicle operated only on a rail line. And I looked around, I couldn't find
driver, I couldn't find operator. I was like, gosh, I'm in a corner, aren't I? Told me 3102, right? We're gonna go back to 3101 to purpose and policy. The purpose of this chapter is to reduce traffic accidents and deaths and injuries resulting from traffic accidents. Cool. So therefore it is necessary to prescribe motor vehicle safety standards for motor vehicles and motor vehicle equipment in interstate commerce. Now, I mean, commerce is part of the word item there, but we'll look it up anyway. Number 5, interstate commerce. Of course it would be 5. Interstate commerce means commerce between a place in a state and a place in another state, or between places in the same state through another state. And to carry out needed safety research and development. It's and, so it would have to be both, so we can fold it back onto it does have to require. The base requirement is that motor vehicles are operating in interstate commerce. It all still comes back to commerce. Are you operating in commerce? No. Doing private activity. Exercising your right.